I want to thank the sponsor of today's video, and that's Arms Directory. Arms Directory is the only two-way protected social network and marketplace. You can post your favorite pics, you can talk about acquiring things and local events in the area, and also post videos of your favorite upgrades. I want to thank them for being the sponsor of this video. You can check them out at armsdirectory. You know what. Hey everybody, welcome back to Guns and Gadgets. This is take two because after I did this whole video, I realized that my memory card was corrupted. So, gotta do this all over again. All right, I want to let everybody know that today, this morning in California, in the lawsuit, in the case where Defense Distributed and Second Amendment Foundation are suing California for two things. One is their law that is putting a ban on self-manufactured firearms, as well as a prohibition on the tools in which you could use to do that, specifically like the ghost gunner, as well as California's new law, which will allow the state to seek fees and costs associated with defending these Second Amendment cases. That's supposed to go into effect on the 1st of January 2023. And the reason I'm bringing this to you is because the way that Judge George Wu, who was a George W. Bush appointee, he's from New York, so he's probably an anti-gunner. Big assumption, I know, but it's probably true. He bastardized the decision in the New York State Rifle and Pistol Association. He twisted it so that it works for gun control, and it's disturbing. Now, the document I'm going to read from is from his civil minutes in his tentative ruling on the plaintiff's motion for preliminary injunction. This came out, was filed yesterday. This happened Friday afternoon in the judge's chambers, and this ruling is going to come down today. On August 31st, 2022, Defense Distributed and the Second Amendment Foundation filed a lawsuit against Robert Bonta in his official capacity as the California Attorney General and Luis Lopez in his official capacity as Director of the California Bureau of Firearms. The operative complaint in the action is now the first amended complaint for declaratory and injunctive relief, with Defense Distributed listed as the sole plaintiff in the action. And on September 23rd, Defense Distributed moved for preliminary injunction, asking the court to enjoin the defendants and any others in active concern or participation with them from enforcing the California Penal Code sections that are challenged here in this lawsuit. Now it says the court will deny Defense Distributed's motion. In brief, the court would find that given the purpose of California's regulation, the balancing of equities and public interest are not so one-sided in Defense Distributed's favor as DD appears to believe, even if DD was able to demonstrate a likely violation of Second Amendment rights. As to AB 1621 and the penal code provisions it introduced, the court does not believe DD has demonstrated at this time a likelihood that it would prevail on the merits of the Second Amendment claim, or even that there are serious questions going to the merits on that issue, and necessarily it therefore has not demonstrated a likelihood of irreparable injury. As to SB 1327, the defendants have made it clear that they have no intention of enforcing its provisions against DD, i.e. seeking attorneys' fees and costs pursuant to that authority in connection with this litigation. Now, the parts I'm going to read to you right now, stick with me. This is where this judge has contorted Clarence Thomas's ruling here, the 6-3 decision that the Supreme Court came down with, saying that the Second Amendment is a core right, and that in order for an infringement to remain, it must pass the text, history, and tradition test. If it's not in the specific text, the simple text of the Second Amendment, it must then be proven by the government that it is in the nation's history and tradition of gun control in and around 1791 when the Second Amendment was adopted. And what this judge here does, Judge Wu, is dangerous, and I'm guessing we're going to see this going forward once this decision drops today. You're going to see other anti-gun states use this, and my guess is you might see it in New York very soon as well. In Bruen, the Supreme Court held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. In that situation, if a government seeks to justify its regulation, it must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Though it leads with the recognition of the primacy of Bruen's plain text point, DD seeks in its opening brief to jump ahead in the analysis to a historical tradition assessment and to jump ahead in Bruen to that decision's discussion of how to conduct such an assessment. But it has effectively attempted to avoid the necessary threshold consideration. Does the Second Amendment's plain text cover the issue here? No, it plainly does not. AB 1621 has nothing to do with keeping or bearing arms. To determine whether the Second Amendment's plain text covers an individual's conduct, courts must first identify and delineate the specific course of conduct at issue, which in Bruen was carrying handguns publicly for self-defense. Under DD's own characterization of the penal code provisions introduced via AB 1621, what is at issue here is a ban on self-manufacture of firearms and a prohibition on the sale of the tools and parts necessary to complete the self-manufacturing process. Try as you may, you will not find a discussion of those concerns or any such rights in the plain text of the Second Amendment, which says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. DD implicitly recognizes this, but it argues that the Second Amendment's recognition of a right to keep and bear arms implicitly includes the right to acquire and manufacture firearms and necessarily involves the right to purchase arms. But whether or not it does so, its analysis is quite clearly not a plain text analysis required under Bruen. Even beyond that point, DD has not pointed to any clear regulation in AB 1621 of any perceived rights concerning the acquisition or purchase of arms. Much as DD would like to move history and tradition forward in the course of relevant analysis under Bruen, its attempt does not survive a careful and intellectually honest reading of that decision. In the end, as defendants argue, under Bruen, the burden does not shift to the government to support the regulations with a historical analysis and DD's Second Amendment challenge, at least for purposes of this motion, fails at the threshold stage of the inquiry. DD, and apparently certain other courts, would like to treat the Supreme Court's Bruen opinion as a word salad, choosing an ingredient from one side of the plate and an entirely separate ingredient from the other, until there is nothing left whatsoever other than an entirely bulletproof and unrestrained Second Amendment. That is not how precedent works. It is not even how language works, let alone salad in most instances. Under the analytical framework established in Bruen, DD has not demonstrated at this time either a likelihood of prevailing on the merits or even a reasonable probability of success in connection with its case against AB 1621. If there is some other non-Bruen framework that could give life to its challenge to AB 1621, Defense Distributed has not yet identified or defended it. With no demonstration of a likely Second Amendment violation at this point, no irreparable harm is likely. DD therefore cannot satisfy either of the two arguably appropriate tests for preliminary injunctive relief, and its motion insofar as AB 1621 is concerned is denied. The judge also said in their challenge to SB 1327 that it's denied as well because California told Defense Distributed and Second Amendment Foundation, we're not going to come after you for the fees associated with this as well, so that was denied too. And then the conclusion says, whatever the above discussion might mean for the future of DD's case, a preliminary injunction is an extraordinary remedy. For the reasons set forth above, DD has simply not made a case for its issuance here. The court therefore denies the motion. So this judge is saying that other courts have gotten it wrong post-Bruen and that it's not on the government to prove that their restriction falls within the text, history, and tradition. It has to be in the text first, meaning our right to keep and bear arms. And once they say it's in the plain text, then it becomes the government's job to prove that their restriction has a historical analog as far as, being something that was traditional as far as gun control. This judge has it wrong. It's not first it must be protected in the plain text. If it's not in the plain text, then it must pass the history and tradition. So this judge has it wrong. And my guess is once this drops today, we're going to see this pop up in other states and anti-gun trials that are going on. And this is no bueno. This is no bueno at all. Now, this is the exact opposite of what a federal judge in Delaware said when they said that the attempt of the government to stop people from making their own guns was against Bruen. It was unconstitutional. So now we have two circuit courts in opposite agreement of each other and with opposite decisions. Although this case here, Defense Distributed, is still going forward, the court hasn't given a final ruling on the whole case yet. It bears watching. I'd also like to add that there is a well-documented tradition in this country's history of people making their own guns. Also, it bears watching here once this drops today is that a denial of a preliminary injunction is appealable directly to the Supreme Court. Will that happen? We'll have to see what Second Amendment Foundation and Defense Distributed decide to do, but it definitely bears watching. And also, because this is a district court, whatever the final ruling is can be appealed to the Supreme Court as well. So this could end up on SCOTUS's doorstep immediately, or after the final decision is made once the case comes to a close at the district level. So this definitely bears watching. What do you think about the way that this judge contorted the ruling of Bruen? Do you think we'll see it again? Do you think it'll be a pain or a hurdle for us to overcome going forward once more anti-gun judges latch onto this? I'd love to hear your opinion on it. And if you want to help get this information out, I ask you to please do the following. It'll take you about 5 seconds. Click the like button, share the video, and make a comment down below. It definitely helps the channel. And last night, myself, Anthony from the Armed Scholar, Braden from Langley Outdoors Academy, we were all texting each other. The algorithm has definitely affected all of us going towards the elections. Go figure. Why would they want that to happen? So the way you can help us all the channels you watch, is to like, share, comment, and of course, subscribe to the channel. It takes you about 5 seconds to do that, and it definitely helps all of us out. And until we see each other again, be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. Because it's in the text, the plain text, the simple text of the Second Amendment. It is also in the nation's history and tradition. And this judge has it wrong. If you want to stay in the loop, subscribe to the channel, and I'll see you on the next one. Take care.